Hi, and welcome to the Hofline, your online hotline, direct line to the women-only attorneys at Hofheimer Family Law. My name is Katie Carter, and I'm so glad that you're here. I'm an attorney at Hofheimer Family Law, a Virginia-based family law firm dedicated to representing women exclusively in divorce, custody, and support cases. I'm here today with Lorna Rose, an attorney who practices with our firm. Thank you for joining me today, Lorna.
Hi,
Uh,
Katie.
I wanted to talk today about settlement and the alternative, which is having your day in court. It comes up in a lot of our cases, and at some point, many
Mhm.
of our clients have to face a difficult decision about whether they're willing to reach an agreement or whether they'd prefer to leave it up to a judge to reach a resolution in their case. Settlement or settling has kind of a negative connotation in legal cases. Lorna, can you talk a little bit more about the decision that goes into, or what's involved in a decision to settle a case?
Sure. It's a lot of different factors and facts that go into the decision about whether to settle a case, but the predominant thoughts relate to what do we predict a judge would decide in your case. Our job is to offer a recommendation to you about what the likelihood of your case and how it will turn out if we end up with a judge making the decision. So, if we think that a judge would make a decision that's not as favorable to you as what is currently being offered by the other side, or that may be offered by the other side, then we have many discussions about whether we should pursue a settlement because we do not believe that we would get an outcome that is more favorable with the judge. And when I say favorable outcome, often that can mean really details. Judges are able to make broad decisions related to parenting time. They're able to make big, broad decisions related to property, but they really lack flexibility and creativity. They don't have the legal authority to make rulings that might actually be what you want to have in your case. We obviously want to hear from you about what your priorities are. What are the most important things for you to obtain in this case? And then it's our job to match that criteria, those priorities, to what we think the judge could do for you. And if the judge can't do those things for you, we need to tell you that and then decide if there's any way we could negotiate with the other side to obtain some, if not all, of your objectives.
Yeah, I think settlement has sort of taken on a negative connotation, mostly because the experience that we have with the law is a lot of what we see on TV. And a lot of
Mhm.
the cases that we see are not necessarily family law cases. So, in, for example, a personal injury context, saying, an insurance adjuster saying that they're going to settle a case means that they know they're going to lose, right? So they avoid going to trial and they negotiate something so that they don't have to go in front of the judge. It's very different in family law. In most of these cases, it's really not a case where someone is going to win the day and someone else is going to lose. There most of the cases there's, a bit of give and take. You win some, you lose some. So it is a question, like Lorna, like you said, of setting goals and creating a list of priorities and then working to engineer a settlement offer that reflects those goals and priorities and gives you more flexibility over the outcome as opposed to what the judge would be able to do if you did go to court. In all of our cases, there are a number of different opportunities to reach a settlement that, the court kind of specifically puts roadblocks in place, like requiring you in some instances to participate in mediation or to have a judicial settlement conference before you can have a trial date. So there's a lot of different opportunities kind of built into the structure there to help give you that control over the outcome that can only come from coming up with specific terms yourselves between you and your soon to be ex or your child's father, whoever it is on the other side. It gives you a lot more control and a lot more flexibility and a lot more um, latitude to meet the specific needs of your specific situation and your particular family. So I would always tell a client, someone who was talking to me about it, to not try not to view settlement through a negative lens and try to look at it as an opportunity to kind of craft a solution that works for you, as opposed to having a solution kind of be forced on you, having it happen to you passively, and participating
Mhm.
in it like in a more active way. I know you've been really
Right.
successful, Lorna, especially in some recent cases, getting some pretty creative solutions engineered for your clients, and I'm sure that it really improves, the post divorce life to have some say in how it's all handled.
Right. And sometimes we have to explain to a client that based on our experience, based on the types of cases we've handled, that the outcome that the client desperately wants is not going to be achievable. So
Yeah.
our job is to tell you that the likelihood of a judge giving you, for example, 100% of the parenting time is unlikely. This again is just a hypothetical, but if that's the advice we are giving you, then it is to your benefit to work within that advice to then craft detailed solutions within the framework that you are unfortunately going to have to live with, because it's not us making the decision at the end of the day. The law and the judges do. And if you go before a judge, and my advice is that the judge is going to give the father equal parenting time, then you're going to perhaps end up at court with a judge giving you exactly that type of ruling and then nothing else, no other details, no other modifications, no other specifications related to your unique circumstances in your family. So sometimes in this process, you're going to hear information that you may not ultimately like to hear, but it is far more empowering to hear that information sooner rather than later, and then work within that framework to come up with the best solution that we can possibly come up with, given the realities of the legal system that we have to work within.
Yeah. It's important not to discount the emotional energy that's involved in some
Mhm.
of these contentious cases, and the way, like, as you're approaching your own contested case, whether it's divorce or custody, or something else, all the things about how you're feeling are really going to impact the decisions that you're able to make, and whether or not you're able to even consider settlement as an option. But the
Mhm.
fact is that in a lot of these cases, we are often negotiating up until moments before the trial is set to start. At
Mhm.
that point, it's different than if we were able to settle earlier, because the attorney would have done absolutely everything necessary to prepare for your trial.
Mhm.
So it's probably not ideal, but is there still an advantage, Lorna, to settling, even on the courthouse steps, as the saying goes?
Yes, I think so, because no matter when you settle, the question you're still going to have to ask yourself is, what is the likelihood I'm going to get what I want from a judge? And
Yeah.
that won't change it doesn't matter whether you're asking that question on the courthouse steps or a few months before the trial. That is always the guiding post is, well, is it going to turn out less favorable to me, or I will have less control over details or specifics that I would like, if I proceed to trial. I'm not going to lie that when we do settle right out the courthouse, it is more stressful for
Mhm.
attorneys too, because the court is waiting on us. We simultaneously are prepping for a hearing and to present evidence, but at the same time, we as attorneys are working out the terms of a potential settlement.
Mhm.
So, and sometimes those last minute negotiations are out of our control. We can't control when the opposing party decides to participate in the case. We can't necessarily we don't have control over the prep that his or her attorney does prior to the hearing. Sometimes attorneys prep things last minute and we get a settlement offer last minute, not because of either of the parties, but because of the other attorney. So some of these things are out of our control as far as last minute negotiations go. But some of the last minute negotiations can be prevented if we are being proactive, meaning me and you as the client attorney, where we're talking about, well, let's make a proposal, let's make a settlement offer, let's
Yeah.
give them a week or two to respond and see what they come back with. That can, in some circumstances, prevent last minute negotiations. But that does require the client to be proactive first in coming to an attorney sooner rather than later. Coming to an attorney right before your trial is a challenge because it
Yeah.
just eliminates so much opportunity for you and your attorney to develop a trusting relationship, for the attorney to really prepare your file, and for you to understand the advice that your attorney is giving you. So if your attorney is giving you advice that you do not like and it's the eve of your trial, there's not much, you're able to do at that point in terms of not being able to get a second opinion or
Mhm.
um, ask more questions of your attorney. The time constraints are just too limiting at that point.
Yeah.
So a lot of what we can do is controlling our timeline and um, and then working as best we can to um, ensure that the other side has the information they need from us to propose a solution. But sometimes it's out of our control. And if it is, accepting that is important, because the more emotional you let yourself get during those last minute negotiations, the less productive it is, I believe. And I have to do this myself, where I have a lot going in my head.
Yeah.
So I really try to calm my nervous system, get to court early, have my paralegal prep the file in advance so that I'm not doing last minute trial prep if I can avoid it, so that if there is a last minute settlement proposal, I can focus on that. But the extra negative energy is not going to be constructive. So
Mhm.
we still have to answer this question of, are we going to get the type of result that the other side is proposing to us if we go to a judge? And most of the time, it's not. The judges are very limited in what they can decide and rule on. And the two attorneys and the parties, they really know the case better than the judge is ever going to know the case.
Mhm.
Um, and so, um, it's accepting the reality that we have experience, and um, it's often difficult to tell you one way or the other that, dad is going to get parenting time that you may not like, or the spousal support that you're looking for is likely not going to happen. That's hard, but it is also more empowering for you to know that information.
Mhm.
Um, and then to make decisions based on that being the reality of your case.
Yeah, it's important to have all the information while you still have options available at your disposal rather than waiting until the last minute. And I think you've led perfectly into my next question, Lorna, which is
Mhm.
can you elaborate a little bit more on the main differences between the types of results you can achieve in court versus what you can do when you settle, when you negotiate with, ideally with the benefit of an experienced family law attorney on your side?
Oh, it's worlds of difference, 100% worlds of difference. And one way to illustrate that is, when it comes to, let's say you're in juvenile court, the judges have a sheet of paper, one sheet, and that's where they handwrite their ruling on. And they write that within the span of maybe 3 inches on this paper. The rest of the paper is just who's the party, who are the parties, who are the attorneys, and the case numbers. But the actual substance of the ruling is notated in a little space on this one-page order.
Yeah.
And that's all you're going to get from a judge. So
Mhm.
when it relates to spousal support, custody, or visitation, it's a couple of sentences, maybe max. If you negotiate and reach a settlement agreement with an opposing attorney and the other party, our settlement agreements are comprehensive. I mean, that is
Pages
the
and
goal, is
pages.
pages to think of every potential as much as possible, knowing we can't predict we don't have crystal balls, but we can address these scenarios that you've told us have occurred in your life and that you would like to prevent going forward.
Mhm.
And so just that, the visual of a 3 sentence order versus a 10-page order that's been negotiated, I mean, I think that's a reflection of what is the difference that you're going to get when you settle. Even if you settle last minute at the courthouse steps, your attorneys can be writing down these provisions that you've agreed to, and
Mhm.
thereafter, if you still haven't worked out like the nuts and bolts of something, the attorneys can go back and fill those details in.
Mhm.
But you're not going to get that sort of attention from a judge at all.
Mhm. Yeah.
Um, and furthermore, um, ex aside from the details, the judges are limited, again, in what they can actually decide. So, one example would be that in spousal support cases, the judge is very limited. They can award a lump sum, they can award a dollar amount, and they can set a duration. But when you're negotiating, you can negotiate so many variants on spousal support. Your spousal support could be non-modifiable. It could be paid in certain lump sums over a period of time. It could be in exchange for a different asset, for example. So you're again, there's so much more creative solutions in a settlement than in court.
Yeah.
And sometimes court is really the only option. And that, in my experience, is the only option when the other side refuses to negotiate or is so unreasonable with their terms that my advice is, well, then you're going to end up with a better outcome with the judge. And every case is so different. So I do think that another part of this process is finding an attorney that you can build a trusting relationship with, because this is important advice that you're going to be getting, and it may be different advice from what your friends and family are telling you, because but at the end of the day, an attorney is there to give you a legal opinion, not what's necessarily a
Yeah.
just opinion about what's right and what's wrong. It's a legal opinion about what are the realities of your case, and helping you find a pathway in the legal system to come out as whole as possible. And
Yeah.
if you have children, that is as good a solution as best for your kids as possible in this situation that you're in.
Yeah, I mean, it's a big ask, right? I think it's always a big ask to be like, "Oh, well, I'm an attorney, just trust me." So, I mean, I
Yeah.
know, Lorna, you said it a minute ago, but one of the most important things you can do to prepare for your case is to be proactive, to research attorneys, to ask questions in your initial consultation, and really, really get a sense of that attorney before you hire them. Getting down to the last minute is always going to be a challenge in the sense that then tensions are amplified, the pressure is on because you just have a limited amount of time. So
Mhm.
then, getting into a case and getting advice that you didn't really want to hear or that doesn't jive with what your intuition tells you or what your friends and family are telling you, I'm sure that that can be a really harrowing experience. So you do want to make sure that you've done the work up front, ideally as proactively as possible, to interview and question and find the right attorney, someone that you can trust, even though you probably won't have spent, a ton of hours with us before we're, giving you advice about some of the most intimate details of your life. But you can always get a second opinion too. I mean, I think that you can do that in the early stages when you're interviewing attorneys by meeting with two or three different ones just to get a sense of different personalities, of different advice, in your situation. But you can also do that once the case is going on. So if you don't like or don't trust the advice that you've been given, I think that's always an opportunity to have a conversation because you're financially invested in the current attorney that you have. But it's still an opportunity to get a second opinion. And I personally would never be offended if a client of mine got a second opinion, a client questioned my judgment or had follow up questions about something that I said. I would much rather we have an upfront conversation about exactly what the issues are and what your questions are about it, so that I can help make sure you feel as good about it as possible. Because in general, especially with respect to equitable distribution, like how the property is all divided in your divorce, there's no taking it back. You're bound by any agreement that you reach. Custody, visitation, child support are all modifiable based on a material change in circumstances. So that's a bit of a silver lining if you negotiate something and are then questioning it later. But that also leads me into my final question for you, Lorna, which is, have you noticed that any of your clients have gotten some kind of, I mean, I'm sort of calling it buyer's remorse after settling. What would you say to someone who settled and then wondered later whether litigation might have actually been a better option for them?
Well, I can speak for my cases and how I felt about those situations. I always feel that I give the best advice that I can give. It's certainly not in my interest to make you unhappy or to give
Yeah,
you poor advice. It's not in my interest, nor I'm not that type of person. So when those situations have happened, in my particular cases, I think part of the problem is that it's likely to happen when you retain last minute, when there's a complicated case, probably whether it's property, spousal, but also really when it relates to your children. If it's a complicated custody case and you retain right before the trial date, and even if you retain a week ahead of time, that's still last minute in the legal world, in the legal scheme of things.
very, very
So
last
when you
minute.
retain very last minute, and so there isn't that time to build a trusting relationship for you to process what your attorney is going to tell you, and it's not a lot of time for the attorney to gather all of the facts in the case.
Mhm.
We are on your side. But being on your side doesn't mean that we take everything that you say as um, how the case should end up. The facts are the facts, but there's facts that are coming from not just the client and the people that we're representing, but also from the other party. Um, Prior rulings, potential like evaluators and a guardian ad litem. It's our job to gather all of that information, and your facts and your version and your goals and your concerns, and then tell you based on all of that information and give you a recommendation based on all of that information what the court is likely to rule, so that then you can decide whether you want to go to court or settle. And when we don't have time to process all of that information, I think clients end up having buyer's remorse after the fact. Um, and I do think sometimes the emotions related to what we call bad facts can sort of cloud judgment after the case settles. So the facts are the facts. And whether they're being interpreted by me or ultimately the judge in a way that you agree with or don't agree with, that's almost irrelevant. The facts and are what they are. And if you caused a bad fact, we're not judging you, we're not shaming you. Our job is to say this is a bad fact and this is how it's going to impact your case.
Mhm.
And there can be a lot of emotions tied up with these facts. And so my advice too is if you are feeling those emotions after the fact, go back to your attorney, repeat what your attorney had told you. Go get support from professionals to maybe help process, potential trauma that you've experienced, because that clouds our judgment. It's hard to be objective when we've undergone a lot of stress and trauma associated with this other person in
Mhm.
the case. And then while you do have friends and family that have your back, also keep some distance, because they weren't giving you the legal advice. They weren't the party in the case, and they don't have all of the information that you and your attorney had. So I think part of it is really just doing self-reflection and finding a path forward, and maybe accepting that as much as we don't like the outcome, it might have been the best outcome that could have happened given where your case was. And that's a win. That's a win. And we can always move forward. And so it's about framing our mindset,
Mhm.
despite not liking certain parts of the outcome.
Yeah, and if you haven't been to court a lot, then I think it's easy to, sort of romanticize what might have happened, especially in
Mhm.
the sense that you reach a settlement before your case goes to trial. You didn't have that alternate experience, so there's a stone left unturned, and you're wondering, "If I had gone to court, would it have been different? Would the judge have been so convinced by, my side of the facts that I would have won, that I wouldn't be in this position. And it's difficult to argue with a hypothetical about what might have happened had an alternate reality existed. But
Mhm.
my experience is that in general, going to court is not a validating experience. Most of the clients win some, they lose some, and in many, many cases, they also face a lecture from the judge about the choice of both sides, not just my client, but both sides. About the things that the judge feels that they're doing wrong. I find they're kind of aggressive about those sorts of things. And I even had
Mhm.
one like tell my clients that their kids were gonna like end up in jail if they continued on this path. It felt very aggressive. But so I don't think anybody walks away feeling really good after trial. So I mean, if that's what you are imagining it to be, I think that is probably not all that grounded in reality. But you can talk to your attorney. I would encourage my clients to talk to me again after we settle, or after we didn't go to trial. If you had follow-up questions, or if there was something you wanted to know about how I think it would have gone, or if you're having questions, yep, like have those conversations, because I think it will help make you feel better. In general, I don't think settlement is a bad thing. I think we would all agree that settlement is a good thing that gives you a lot more control over the outcome. And when we're talking about dividing up custody and visitation of your children, we're talking about support. We're talking about dividing your retirement accounts, your bank accounts, your cars, like all the things that you've spent your entire married life building together. I mean, nobody has a more vested interest in how this all works out than you and your soon to be ex. So ideally, you guys are going to be able to come together to reach a kind of solution. But I don't know if you had anything else to add, Lorna, but I think this is all really helpful information.
Absolutely, and it's a tough decision. It's probably one of the toughest decisions you are going to have to make while you are involved with the legal
Mhm.
system in a divorce or a custody or support matter. It is
Mhm.
a really hard decision. Ultimately, though, it is your decision to make. No attorney can make this
Yeah.
decision for you. Uh, our job is to facilitate that decision-making process, and give you as much information as we can give you. Um, I think that there's just so many ways for you to take ownership of this decision and be as proactive as possible so that you can make the best decision for yourself. And that takes time, that takes um, concerted efforts from the very beginning,
Mhm.
and procrastinating or ruminating, um, focusing on a few of the issues as opposed to the big picture can really inhibit your ability to make this important decision. So I just encourage you to um, find an attorney that you can trust, build that relationship with your attorney, and then work on your inner strength and work on your abilities to take ownership of your new life
Yeah.
and run with it, because this is your life, it's not mine, and you can make a great decision. Um, and I think the women who have taken ownership of these types of decisions that they have to make end up coming back and saying, this is where I am now. This is how much I've grown.
Yeah.
This is how much I've learned to, deal with my ex. And it's really empowering and amazing to see the growth. And it's at your fingertips.
Yeah.
It's learning to embrace this. I mean, it's really empowering. So
Yeah.
um, I've had to learn how to do it myself. Nothing comes easy, and with this type of, inner strength. But I do think the alternative is far worse. And so uh, it 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 can be a really good thing for you to take these steps to take ownership of a decision like settling your
Ah,
case.
so well said, Lorna. So perfect. I couldn't have done it better. I have nothing else to add. I have nothing else to say. That was
Oh
so great
yeah.
and so helpful. Thank you so much, Lorna, for joining me here today. And thank you everyone else for tuning in and listening. Please feel free to check out our website at hoflaw.com. That's HOFLAW.com. We've got 4 free books, a number of free reports, blogs, and articles. 2 seminars, one on divorce and one on custody, all designed to help Virginia women facing divorce and custody cases make the best possible decisions for themselves and their families. And if you're facing a decision about settlement, then I think you've listened to something that will hopefully be very helpful for you. So thanks for tuning in, and we'll see you guys next time.